Namaskar class, this is Jv'n Devashree Awasthy from the Faculty of Law and Governance. Today's topic is kind of domicile under the private international law. As earlier class, we already discussed about the meaning of domicile. So, in today's class, we will discuss about the kinds of domicile. So basically there are three kinds of domicile. First, domicile of origin. That is by operation of law, every person acquires a domicile of origin at birth which can never be extinguished. Even if a person obtain a new domicile via choice or by dependence, the domicile of origin is never completely lost. It merely lies dormant in the background and revives itself if gaps in acquiring and losing domicile emerge. A law of domicile has developed predominantly through common law rule. In English law, domicile of origin was ascribed according to the status of child as legitimate or illegitimate in the following ways. First, a legitimate child takes the father domicile at birth to be his domicile of origin, and the illegitimate child takes the mother domicile. So, development of domicile origin, which is ascribed to a person when he or she is born. Lord Westbury remarked in the leading case that is, that no one shall be without a domicile, and to secure this result, the law attribute to every individual as soon as he is born the domicile of his father, if the child be legitimate, and the domicile of the mother if illegitimate. Domicile of choice, second kind of domicile, which means any person not legally dependent on another may acquire for himself, herself, a domicile of choice at any time by means of physical residence in a place other than that of domicile of origin and intention to reside there for the foreseeable future. However, anyone not sui juris will rely on derivative domicile which is based on the domicile of those on whom they are legally dependent. This includes children and some persons mentally incapable. The general rule for mentally incapacitated person is that they retain the domicile they had before becoming incapacitated. So, there must be freedom of choice of residence, not prescribed or dictated by any external necessity, such as the duty of office, the demand of creditor, or the relief from illness. And it must be resident fixed, not for limited period or a particular purpose. Under this kind of domicile, main two terms are important, that is, capacity of acquiring domicile of choice, acquisition of a domicile of choice. So third kind is domicile of dependency. The operation of law, the domicile of certain person depend on the domicile of other, since these persons are incapable of choosing their own domicile, like infant, lunatics, married women. The Law Commission in Britain during 80 had to come to a decision concerning the issue whether domicile of children should have domicile of dependence with respect to their parents, or it should be depending on their habitual residence or the country with which they are most closely connected. It was proposed that a child should have a dependent domicile of their parents, but where the tie with the parents was weakened, he would have an independent domicile. Three rules were suggested for ascertaining the domicile of children. First, if the child lives with both parents, his domicile would be same as that of the parents, and it will change with the change of parents' domicile. But if domicile of both parents is not same, then the child will take the domicile of mother. Secondly, if the child is living with single parents, he will have the domicile of that parents, and it will change accordingly. Thirdly, a child should be domiciled in a country with which he is more closely connected. Thank you.